Okay, we're going to get started. We have here the representative from the International Intellectual Property Alliance. Could you state your name for the record?
My name is Kevin Rosenbaum with the International Intellectual Property Alliance, IIPA. Thank you for the opportunity to present the views of the IIPA in this year's Special 301 process. We applaud the U.S. government for making this Special 301 review a catalyst for positive change to address the challenges faced by the U.S. creative copyright industries in key markets abroad. We welcome the chance to participate again in this crucial annual dialogue. IIPA is a private sector coalition formed in 1984 of 5 trade associations representing U.S. copyright-based industries. The core copyright industries combined, according to a December 2016 study, contribute over $1.2 trillion to the U.S. economy, provide 5.5 million jobs, and almost 7% of the gross domestic product. Our members are the Association of American Publishers, the Entertainment Software Association, the Independent Film and Television Alliance, the Motion Picture Association of America, and the Recording Industry Association of America. These associations comprise over 3,200 companies producing and distributing materials protected by copyright laws throughout the world. To reach foreign markets through legitimate state-of-the-art distribution channels, these companies rely on 4 main elements: consistent modern standards of copyright protection, efficient copyright enforcement, sound legal structures for licensing, and the elimination of market access barriers. Progress in these areas advances U.S. trade goals while enabling our trading partners to develop and expand their own cultural and creative output. The ultimate objective is to promote markets where the creative industries can bring even more products and services than they currently offer in an increasing variety of ways from a greater diversity of players before an ever-growing global audience. Advancing that objective is a proven means to grow U.S. exports, create good American jobs, and enhance U.S. global competitiveness. With this broad vision in mind, IIPA has participated in every Special 301 review since the 1988 Trade Act created this process. Given some of the other comments provided, it is worth reviewing the specific statutory language and purpose of the Special 301 review, namely to identify, quote, foreign countries that deny adequate and effective protection of intellectual property rights or deny fair and equitable market access to U.S. persons who rely on intellectual property protection, unquote. It is critical for the Special 301 process to maintain this focus on intellectual property protection, in our case, copyright protection and enforcement. There are those who ask you to dilute this focus to weaken protections and enforcement in order to accommodate the perceived interests of business sectors that, by their own words, depend on expanding the zone where copyright protections do not apply. This is not what Congress intended when it created the Special 301 process and is not consistent with the clear statutory language of Special 301. This is not the approach that has made Special 301 so successful, and the Special 301 process is not the place to advocate that our trading partners weaken their copyright regimes, and especially in countries where legitimate copyright rights holders cannot get a toehold due to grossly inadequate copyright protection or enforcement. In this year's submission, IIPA recommends that 19 countries be identified in the 2018 Special 301 report. All these are listed in our hearing statement with capsule summaries on the 9 countries we recommend for inclusion on the priority watch list: Argentina, Chile, China, India, Mexico, Russia, Taiwan, Ukraine, and Vietnam. Our submission highlights 5 legal reforms that our trading partners should focus on to adequately and effectively address all forms of piracy in a fast-changing technological environment. Most fundamentally, U.S. trading partners must both accede to and fully implement the WIPO Internet treaties, which set global minimum standards for copyright protection in the digital environment. Furthermore, in many countries around the world, copyright reform efforts have become a vehicle for proposals that threaten well-established global norms, including, but by no means limited to, the requirement to confine all limitations and exceptions to copyright protections within the well-established 3-step test. The U.S. government should urge U.S. trading partners to adhere to current and evolving global norms, in particular regarding duration of copyright protection. The U.S. government should also ensure that the numerous bilateral and multilateral trade agreements, including the WTO TRIPS agreement, a score of free trade agreements, and a wide range of other bilateral agreements into which the U.S. has entered, realize the goal of opening foreign markets to U.S. goods and services dependent on copyright protection. To this end, it is important that trade agreements keep pace with evolving global norms for copyright protection and enforcement and evolving technologies, and that U.S. trade agencies make it a top priority in 2018 to address the troubling gaps and shortfalls in compliance with obligations taken on by U.S. trading partners in these agreements. Our submission also lists 6 enforcement challenges confronting the U.S. copyright industries seeking to compete in overseas markets, starting, of course, with internet and mobile network piracy, an overarching challenge for all businesses that depend on copyright. The growth of new, fully licensed, and legitimate channels for consumers around the world to access creative content in a variety of new and innovative ways has been one of the most encouraging trends in the global markets for copyright material. Conversely, the entrenchment of infringing services, including those that profit from enabling others to infringe copyright, is the leading barrier impeding the full access of U.S. creators and producers into markets worldwide. This infringement threatens the viability of licensed platforms, and it makes it much harder for creators and producers to earn a living from their craft. We applaud the U.S. government for establishing an annual review of notorious markets, which has already made a significant contribution in combating systemic online copyright theft, and we urge you to redouble efforts to encourage our trading partners to adopt legal frameworks that create incentives for legitimate network service providers to work with rights holders to advance the common goal of a safer, cleaner online marketplace. Achieving that goal requires the active cooperation of all participants in the e-commerce ecosystem. Our trading partners should be doing much more to foster and encourage such cooperation and the development of best practices. Furthermore, where notorious online marketplaces are hosted in one country, but target consumers in another or worldwide, the failure of the host country to take effective action against them pollutes the markets of its neighbors and trading partners. Increasingly, responsible governments are pushing back against this offshoring of enforcement responsibility. So long as less responsible states fail to institute effective means to crack down on pirate operations based within their borders but readily accessible worldwide, this trend will continue and deserves the close attention of the U.S. government. Finally, all efforts to address copyright infringement will be unsuccessful if legitimate products and services cannot be brought into a market to meet consumer demand. Whatever form they take, market access restrictions that unfairly impede the entry of legitimate products make it easier for pirate operations to fill the void. U.S. officials should continue to strive to eliminate or phase out market access barriers. The health and competitiveness of the U.S. economy depends on a thriving copyright sector that creates revenues, jobs, and exports. But promoting and respecting intellectual property rights and opening markets to products and services that depend on copyright also helps our trading partners. Special 301 remains a cornerstone of the U.S. effort to advance modern levels of protection for copyright, more effective policies and tools to enforce that protection, and freer, more open markets. We look forward to our continued work with USTR and other U.S. agencies to advance these goals. Thank you very much, and I look forward to your questions.
Thank you very much for your testimony. The first question comes from USTR.
Some countries are regularly named in the Special 301 report for copyright and related rights issues, but may not necessarily be the largest or most important markets to your members. Are there any countries that you think should no longer be listed in the Special 301 report for copyright-related reasons?
Thanks for that question. Off the top of my head, I do not think that's the case. I'm happy to check further with our members, and we'll provide supplemental feedback if necessary. Thanks.
Thank you very much. The next question is from the U.S. Copyright Office.
Good afternoon. What are the latest trends that you're seeing in online copyright infringement in China? And do you have any estimated trade losses in China due to copyright piracy or separately for market access barriers?
Thank you very much for that question. China is a market where we're seeing pretty much all forms conceivable in terms of online piracy. So, for example, illicit streaming devices. China is a hub for that. Stream ripping services. One particular problem that we highlight is the problem of apps. And this, the app ecosystem fuels all forms of piracy, including illicit streaming device piracy, because these apps essentially facilitate the access of copyrighted content. People download the apps to their either handheld device or their illicit streaming device. So this is a significant problem, and one obstacle to enforcement against these apps has been that China has tended to look at it through what we refer to as the server principle, where if the infringing content is located at a server remotely, which many of these apps, that's how they work. They circumvent protections and they access content on remote servers to the user. Certain Chinese courts have held that where the content is accessed remotely and is not stored on a user's device, then they won't find infringement. And so that's been an obstacle. There was a case in which they did not apply that principle in 2017, which we highlight in our submission. So what we'd like to see is a judicial interpretation normalizing that standard, or perhaps in the copyright law reform process, it can be addressed that way. And as to the second part of the question, it's very difficult to come up with numbers on piracy. I can look to see if there are available, if I can supplement our submission with that. We highlight the Frontier Economics Study on Piracy, which uses a method which we think is actually on the very low side. But it's very tricky when you're talking about losses due to piracy. So happy to supplement if I am able to.
Thank you very much. The final question comes from ITA.
This is a fact-intensive question, so I'll take it slowly. For Taiwan, between January 2017 and today, have Taiwanese prosecutors filed any cases involving piratical websites that specifically target Taiwanese consumers where the server is located offshore, but the acts of infringement are taking place in Taiwan? We're wondering if any of your member companies have filed or explored filing in such instances.
So is the question whether our members have brought such a case to the attention of the Taiwanese authorities?
Right.
Okay, I can look into that. I don't know the answer to that. My understanding is that the legal framework that currently exists in Taiwan does not allow for that kind of enforcement. In other words, the Taiwan authorities say, well, when the infringing content is hosted overseas, we don't have jurisdiction. But I can certainly check, and if I find any examples of that, I will let you know.
That'd be helpful. Thank you.
Sure. Thank you.
Thank you very much for your testimony. At this point, I'd like to invite representatives from the Internet Association to come forward and state your name for the record.
Hi, good afternoon. Members of the Special 301 Subcommittee, thank you for holding this public hearing. My name is Malika Carroll, and I'm Senior Vice President of Global Government Affairs for the Internet Association. IA represents over 40 of the world's leading Internet companies. U.S. Internet platforms are a significant driver of the U.S. economy. The Internet industry represented an estimated 6% of U.S. GDP in 2014, totaling nearly $967 billion, and accounts for millions of American jobs. Hundreds of thousands of U.S. small businesses now use the Internet to reach customers around the world in ways impossible a generation ago. In fact, the Internet has helped the United States unlock a massive trade surplus in digitally delivered services worth $159 billion in 2014. While enabling trade in many sectors, the Internet industry itself is growing in a new sector. Our industry is becoming a major producer and exporter of original content. bringing films, music, and other creative works to audiences around the world. Our member companies are now the new faces of the American content industry, winning Emmys and Oscars and providing digital distribution for streaming-only Grammy winners. Last year, IA members released more films than any other major U.S. studio. Our members spent at least $10.8 billion on content, with plans to invest substantially more over the next several years. IA companies have a strong interest in working with all rights holders to ensure that goods aren't pirated. Netflix, YouTube, Spotify, Pandora, and others help drive down theft by steering heavy users to subscription services. Online services that allow consumers to legally access content have resulted in a 48% year-over-year increase in music streaming revenues, up to $2.5 billion for the first half of 2017, according to RIAA. From this perspective, IA members share common interests with other rights holders in ensuring that our trading partners adopt strong and balanced IP systems. In the United States, we take for granted a balanced and well-functioning IP system that enables the operation and growth of the Internet. Unfortunately, one foundational foreign barrier faced by IA members comes from inadequate and unbalanced systems of copyright and intermediary liability protections in other countries. While proper enforcement of intellectual property rules abroad is essential for our members, and we encourage USTR to take action against illicit activities, it is just as critical for USTR to highlight countries that misuse copyright in a way that restricts U.S. platforms and small businesses online. While our full submission highlighted numerous unbalanced intellectual property regimes around the world today, I want to focus my remarks on what we believe are the most problematic laws and policies that continue to undermine and threaten U.S. innovation and economic growth, particularly in the European Union and in China. A range of legislative proposals, new laws and regulations in both member states and at the European Union represent a significant departure by the EU from its shared approach with the U.S. on the foundational principles of a free and open Internet. For example, the proliferation of ancillary rights and neighboring right laws in Europe directly threaten U.S. Internet platforms. Giving new legal entitlements for quotations or snippets enable countries to impose levies or other restrictions on the use of this information. This is a practice which runs afoul of Article 10.1 of the Berne Convention, raising potential enforcement questions at the WTO. The European Commission is also proposing changes to the Copyright Directive that would drastically shift the landscape of copyright intermediary liability in Europe. The proposed changes would make platforms directly liable for content uploaded by users, proposals that, if implemented, would eviscerate protections set forth in U.S. law. The proposals would also require a broad range of online services to monitor and filter content, and provides for a potentially intrusive multi-stakeholder process regarding the design and operation of content recognition technologies. In addition to unbalanced IP policies in Europe, U.S. Internet services are dealing with different and problematic measures in China that are forcing cloud service providers to transfer high-value intellectual property related to specialized cloud services, software, and hardware to Chinese companies as a conditions of operating in country. This is happening while Chinese companies in the U.S. are able to fully own and control such data centers and cloud-related services here. So we encourage USTR to raise strong concerns about the European and Chinese proposals, recognizing that these continue to significantly increase cost and restrict market access for U.S.-based services. To conclude, it is our hope that this year's report will break new ground in support of the digital economy and recognize the harm unbalanced IP policies have on both internet industry and the U.S. economy as a whole. A modernized NAFTA provides an immediate opportunity for USTR to promote a strong and balanced copyright framework that benefits all U.S. stakeholders. And without these business-critical protections, internet services and the industries we enable face troubling legal risks even when they follow U.S. law. With that, thank you again for holding today's hearing and to give us the opportunity to testify, and I'm happy to answer any questions.
Thank you very much for your testimony. The first question will be from USTR.
Thanks again. You identify several concerns about policies related to intellectual property in various markets. However, you do not make any recommendations about the listing of these countries. How do you think your input should be reflected in the Special 301 report? Are you equally concerned about all trading partners you mentioned?
That's a very good question. Thank you. I'd be happy to work with our members and come back to you with some more precise proposal for that.
Thank you very much. The next question comes from the U.S. Copyright Office.
Good afternoon. You mentioned in your public submission that India's intermediary liability framework poses a significant risk to U.S. Internet services, particularly because there isn't a clear copyright safe harbor framework. Could you tell us how India's ISP liability framework hurts your industry and if there are additional market access barriers in India?
Sure, I'd be happy to talk about that with our members and get back to you again with more details in our post-hearing submission on India. Yeah.
Thank you very much. The next question comes from USPTO.
Thank you. Is the FTA concern that you raise with respect to the Australia FTA a relatively new development for your members? If not, what has been the impact in previous years?
Thank you for the question. I'd be happy to work with the companies to see how that has impacted their business in Australia and get back to you with the post-hearing submission.
The next question comes from DOJ and is presented by ITA.
Your submission explains that ISP safe harbors have been critical to the growth of the internet and to online trade. Can you provide some examples of how a country's lack of ISP safe harbors from copyright liability affects your members' decisions to operate and/or invest in a particular market?
Sure, that was a question we also discussed with you at the hearing last year. I think we could come back to you with some more precise information about those examples.
Thank you.
And the final question is also from ITA.
You've noted that many of your members develop content and rely on copyright enforcement, but in your submission you discuss exceptions and limitations in each specific marketplace. Although some of those countries are well known for not protecting copyright, what accounts for this?
Sorry, what accounts for?
For their treatment in your report, that you're focused on exceptions and limitations instead of their lack of copyright enforcement in a traditional sense.
Right. Again, I'd be happy to talk with the member companies and provide you some more information about how we perceive the difference in the two.
Thank you.
Sure.
Thank you very much for your testimony today. I'd like to invite representative of Knowledge Ecology International to testify, and please state your name for the record.
Thank you very much. I'm James Love, Knowledge Ecology International. I just go ahead and start. Is that the procedure?
Please.
Thank you. First off, I just want to say that there are several things in the submissions by the companies that represent the pharmaceutical industry where they complain about measures all over the world that have to do with drug pricing, not directly an IP issue per se. I just want to remind the committee that President Trump got elected on a promise to negotiate drug prices and to cut $300 billion out of the Medicare budget, which is not even $300 billion, so it was a pretty aggressive cut he proposed. And he's not going to be able to deliver on a fraction of those promises unless he employs some of the mechanisms that the drug companies are complaining about. So you don't want to be throwing down policy mandates in areas that are going to constrain his ability to deliver the promises he made to his own voters to protect them from high drug prices in the United States. I'm going to talk now on compulsory license. I'm going to read from a text I prepared, which I could share if you want. Pharma and other groups lobbying on behalf of big drug companies frequently target the use of compulsory license as a, quote, harmful IP-related trade barrier, quote. KI sees compulsory license as important and very much underutilized as a tool to address excessive pricing and restrictive licensing practices. I'll take a minute to provide some context for this proceeding. First, the United States has at least 15 separate statutes that can be used to permit non-voluntary use of patents, not counting our various exceptions to patent rights for research and uses by medical professionals. Second, the United States is by far, and I mean by far, the most frequent user of compulsory licenses. USTR itself overturned an injunction on the importation of iPhones and iPads that infringe on patents owned by Samsung on August 3, 2013. Under the Supreme Court eBay doctrine regarding the enforcement of injunctions, courts routinely permit infringement of patents when royalties are paid to the patent holder. For another example involving Apple, in 2017, Apple successfully asked a judge for permission to use, without a voluntary license, but subject to an ongoing royalty, U.S. patent number 5,781,752, titled Table-Based Data Speculation Circuit for Parallel Processing Computer. The compulsory licenses under the eBay doctrine are fairly common, about one a month for a while, but less frequently, as parties tend to grant voluntary licenses when it's perceived to be hard to enforce an injunction. And these compulsory licenses cover a wide range of technologies. In the area of medical technologies, the most common compulsory license ordered by the courts are for medical devices and diagnostics, of which there are many, on everything from contact lenses to artificial heart valves to diagnostic technologies. Often the companies requesting such compulsory licenses are innovators themselves. For example, in 2008, Abbott used the eBay doctrine to obtain a compulsory license on HCV genotyping testing patents. Similar compulsory licensing efforts were successful in several high-income countries, including Germany, where Roche was requesting a compulsory license, and in Australia, and the UK, to mention a few other countries. The United States also has used the threat of compulsory license to force more liberal licensing or price discounts in cases where the federal government was a funder of research, including the patents on reverse genetics needed to manufacture vaccines for the avian flu, stem cell patents held by Wharf, the Abbott patents on ritonavir, which is an HIV drug, and the Fabre patents now held by Sanofi, to mention a few cases under the Bayh-Dole Act. In 2016, 51 members of Congress asked the federal government to make more frequent use of this act. Recently, 18 members of Congress asked the federal government to use 28 U.S.C. 1498 to grant compulsory license on patents for hepatitis C virus drugs. And the Senate Armed Services Committee in 2017 adopted a directive to the Department of Defense to use compulsory licenses when prices on Army-funded drugs like Xtandi, a prostate cancer drug, are more expensive in the United States than in other high-income countries. Many persons, including President Trump, have called for changes in the law to allow Medicare to negotiate drug prices. If Medicare negotiates drug prices, it will involve a threat by the United States to withhold reimbursement, narrow formularies, or increase co-payments. All of these measures hurt patients. We want the Congress to give the government more robust authority to use compulsory licensing in order to protect patients, effectively putting the monopoly at risk rather than the patient when there are disputes over prices. Finally, we're planning to ask the Trump administration to use, under existing statutes, either or both 35 U.S.C. 203 or 28 U.S.C. 1498 to end monopolies on at least 3 drugs this calendar year. In every case, there are significant abuses of patent rights and negative consequences for patients. We also call your attention to the fact that there are emerging very big patent thickets for two new important technologies, CRISPR gene editing tools and CAR-T treatment. And we think that at some point the government's going to have to use compulsory licenses to force more liberal license in these areas or suffer the consequences of not doing so. I have an annex here with the statutes that I mentioned. I'm going to stop right here. Thank you.
Thank you very much for your testimony. The first question is from USTR.
Your public submission comments on the Special 301 process and notes that USTR should, quote, reframe its focus, end quote, and use the process to, quote, develop and outline the policies and norms that it wants to promote, end quote. Do you have any specific suggestions for individual countries nominated for or previously included in the Special 301 report? Thank you.
Yeah, I think from our point of view, the fact that trade policy is focused on patents and drug pricing exclusively to promote innovation overlooks the important role of the National Institutes of Health and other government agencies funding, or the same thing in other countries. Secretary Azar, when he was confirmed, as you may have noticed, he made a reference to the fact that he was gratified when the European Union had increased their funding of biomedical research, and he thought that was one of the things that helped sort of readdress the imbalance between the U.S. as the primary supplier of public goods in the medical research area for the whole world. There's just no country that does anything remotely close to what the United States does in terms of public sector research, and most of the scientific advances in diseases are really due to what's being paid for by taxpayers here. We don't really do anything about other countries like Switzerland and other countries, for example, that do next to nothing in terms of funding public sector research. The WHO negotiations have on this issue have often gotten like a very negative impact from USTR because it's perceived as some kind of threat to patent rights, but it shouldn't be seen that way. It should be seen as a complement to the incentives you get from patents. So we think that by solely focusing on the incentives to private companies and ignoring what happens in the public sector, that you have a bias toward the private sector, which doesn't even reflect what domestic policy is in the United States.
Thank you very much. Following up on that answer, we have a question from HHS.
Hi, thanks for your testimony. In your submission, you asked the committee to, quote, look at the trade-related aspects of funding the research that enters the public domain and advances science. Can you elaborate further on this statement and how it relates to the work of the Special 301 Committee?
Well, just yesterday I was taking a look at a drug that cost over $300,000 in the United States, and I was looking at the patent landscape. And I noticed that there was patents from a university in Australia and from a university and a government-funded research center in Belgium, for example, on this particular drug. When the United States funds the research on a drug like Spinraza, for example, which is for a rare disease, the U.S. government retains a royalty-free right in the patents, and it has these margin rights on that. But that doesn't really extend to research that's funded in Canada or in Belgium or Australia or other countries. We thought a reciprocal agreement where we would have access to the patents that were funded in those institutions, and they would have access to the patents that we were funded in some level, at least a protocol where you could actually at least request the use if you felt there was a compelling public person reason to do for. That's an area that we've raised several times in the past with HHS in the past to sort of look at this issue. And that's one trade-related aspect. Another issue is the U.S. gives grants to researchers around the world. But some countries, when they have government-funded research programs, would not make the grants available to American residents. And I think that you might ask yourself why you're being so open and they're not. Another thing is that the NIH puts conditions it requires if you get a government grant to put your research into a publicly accessible archive, so all scientists around the world, whether they're in China, Germany, the United States, or Switzerland, wherever, can have access to that. And those policies are not universal around the world. So I think that in addition to having the data in archives, I think you might also look toward, in some cases, the permission to do machine-generated translations of research in foreign languages so American researchers could benefit from it.
Thank you very much. The final question comes from USTR.
Your submission suggests that USTR address what you refer to as the global crisis in orphaned works. In your view, what might such an examination include, and would it align with the statutory framework?
One of the problems with the orphan works is the extension of the copyright year from life plus 50 years, which is already, in our opinion, too long, to life plus 70 years. And we know that often the companies lobby the USTR to have other countries do that. There's things that can be done to mitigate those effects. One would be to at least permit registration on works that have long maturities, or more. And the U.S. actually does that to some extent. We have, even for any copyrighted work, you can limit the remedies that are available on an infringement case. So they're different if you've registered the work than if you have not registered the work. So I think that those fit within the existing thing. The other thing that the Library of Congress has recommended is it use limitations on liability for works where you can't identify the owner. And the Library of Congress recommended that because it wasn't constrained by the three-step test, which is considered restrictive by the Library of Congress at that time. For that to work, you have to have the flexibility in setting damages for infringement. that exist in the WTO agreement, but it's been threatened by some of the bilateral agreements that USTR has proposed.
Thank you very much for your testimony. At this time, I'd like to call the representatives from the National Association of Manufacturers to testify, and please state your name for the record.
Members of the Special 301 Subcommittee, thank you for the opportunity to testify today. My name is Ryan Ong. I'm Director of International Business Policy at the National Association of Manufacturers, or the NAM. We're the nation's largest industrial association, and serve as the voice for more than 12 million women and men that make things in America. Manufacturing contributed a record $2.25 trillion to the U.S. economy in 2016 and remains a critical engine to grow the U.S. economy, create high-paying jobs, and provide opportunity and prosperity for Americans. Innovation and intellectual property are crucial to that success and the foundation of a globally competitive manufacturing base. The United States has long been a champion for innovation and IP protection around the world. These strong protections are critical for manufacturers of all sizes, but particularly for our small and medium-sized manufacturers, 90% of our membership, for whom the cost and complexity of defending their IP rights around the world can be prohibitively high. Unsurprisingly, manufacturers face challenges in foreign markets from governments that flout international rules and restrict effective protection and enforcement for U.S. IP through their policies and activities. The NAM's formal Special 301 submission discusses many of these markets, including formal recommendations for 10 priority countries such as China and Canada, and information on challenges in nearly 40 others, ranging from Algeria and Korea to Turkey and Argentina. Our formal submission also flags a series of cross-cutting issues, such as global counterfeiting, increased restrictions on legitimate trademark use, and insufficient protection of business confidential data in regulatory processes. But I want to use my time today to highlight 3 specific cross-cutting issues and challenges that our members face. First, we're seeing increasing attempts to weaken the global IP framework through activities and initiatives in international organizations and forums. These are forums and organizations that play a critical role in supporting U.S. foreign policy and U.S. economic growth. But we see an increasing number of efforts that falsely claim that IP is the barrier and an inherent obstacle to policy goals such as health, environmental protection, and development. These dangerous approaches not only ignore the role of innovation in solving these challenges, but also prevent frank discussions about the full range of barriers that block access to important products and technologies, making it both politically and technically harder, not easier, to find solutions that involve all stakeholders. The January World Health Organization Executive Board meetings were a perfect illustration of this challenge. The meeting agenda included a series of reports and plans designed to weaken global IP protections. Front and center were efforts to institutionalize troublesome recommendations from the strongly biased and deeply flawed 2016 UN High-Level Panel on Access to Medicines. This panel's report, which was criticized by the U.S. government under the previous administration and avoided by the Secretary General that launched it, has been resurrected by supporters and pushed onto the agenda in a variety of international forums such as the UN Human Rights Council, the WTO, WIPO, and the OECD. These efforts are troubling enough on their own, but are also affecting national-level policies in critical U.S. export markets such as Chile, Colombia, and Thailand in ways that harm U.S. innovation and high-paying jobs. Now, thanks to strong efforts by HHS and the interagency team, the United States took a strong, robust negotiating line in January and was able to fend off some of the more troubling proposals, but we still face this growing challenge. The United States must be strong and strategic to continue to push back against these efforts, and your agencies have a critical role to play, working through a tightly coordinated interagency coordination process and with other like-minded countries to be able to push back robustly on harmful activities. Second, innovative manufacturers are facing new threats from countries seeking to undermine patent protection that support strong U.S. exports of innovative products. These attempts can come in a variety of forms, which we've laid out in detail in our more detailed submission, but would be happy to answer more detailed questions at any point in time. But we see a range of high-profile examples popping up in markets from Malaysia to Canada, from Colombia to Turkey, from Russia to Japan. And while these policies, including compulsory licenses, can be legitimate government tools when used correctly, they cannot be an excuse for protectionism or as a cover to promote local companies at the expense of U.S. manufacturing, and they must be developed and implemented transparently based on open stakeholder consultation. Third, trade secrets are becoming increasingly critical for manufacturers of all shapes and sizes. Now, the United States strengthened trade secrets protection with the 2016 passage of the Defend Trade Secrets Act, which the NAM strongly supported, and a few other countries and regions have promoted reform to their trade secrets legal regimes, such as the European Union, Japan, and Taiwan, but many others have not. And although the headlines in this space are often dominated by places like China, India, and Russia, countries around the world fail to protect trade secrets effectively through their laws, policies, and enforcement actions. And that brings me to my last and final point, which I'll be happy to elaborate further on in questions. The NAM urges the U.S. government to make strategic use of all available options to promote and protect innovative manufacturing. These must include a variety of tools, from strong enforceable IP protections in current and future trade negotiations, use of robust enforcement tools in organizations like the WTO, robust use of domestic tools, including those provided by the Trade Facilitation and Trade Enforcement Act, and a pro-IP message in international fora. All of these tools are critical. With that, let me thank you for the opportunity to testify here today. I look forward to hearing from you and your agencies with particular questions and/or following with more detail and follow-up questions.
Thank you very much. The first question is from USTR.
Are there any countries that have been listed in previous Special 301 reports for issues of concern to your members that you would no longer recommend we include if, for example, the market is not of the same size or importance as other markets that you nominate? Thank you.
All right, I appreciate it. In looking at our submission, our list of countries where we have issues of concern, I think, has continued to grow. We look each year in consultation with our members to understand and to document the current situation that our members are facing. And throughout our submission, we have noted some areas of improvement. In markets like China and India, there are specific things to be able to point to. That being said, our overall assessment of these markets and of other markets continues to encourage us to request placement for those countries, for example, on the priority watch list, as well as other countries and their classification based on the challenges that our manufacturers are facing now. I'd be happy to follow up with more detail on that if it would be helpful.
Thank you very much. The next question is from Treasury.
Hi. The Federation of Indian Chamber of Commerce and Industry noted as part of its 2018 Special 301 submission that foreign investment has risen to unprecedented levels, with total FDI flows between the U.S. and India at $37 billion in 2016. How do you explain this growth, given the IP deficiencies that you had described?
Sure. That's an excellent question. And in our work on India, in the IP and the non-IP context, we speak significantly about the importance and the robust and increasing interest from many of our cross-manufacturing members in that market. I think the point to come to is that investment in India remains constrained in a number of IP-intensive industries because of the challenges that they face in this market. And of course, those investment numbers include both IP-intensive and non-IP-intensive industries. Many of our IP-intensive and innovative manufacturers are interested in the potential that the India market can bring, but practically and operationally, the significant IP challenges they continue to face in that market restrain their ability to be able to invest and sell robustly.
Thank you. The next question comes from the Department of State.
Thank you for your time. To follow on with respect to India, what are the sense of priorities? You listed many different issues that you enumerated. Is there a hierarchical list in the way that it's listed within your submission, or can you offer us some priorities?
Sure.
Thank you.
So the breadth of our membership means that we have members who care about a diversity of intellectual property issues in India, and many companies look at the market based on their operations in multiple spaces. Certainly the challenges within India on the patent space remain first and foremost for many of our members. Those are the areas, I think, in which we've seen the most challenging areas for progress. Those are the areas in which many of the core and most fundamental issues, including patentability criteria, including Section 3D of the Indian Patent Act and many others, remain largely unchanged, and in which the size of the market is significant enough that there would be both interest in helping to remove those barriers and increasing frustration about the lack of progress, in some cases backward movements in those areas.
Thank you very much for your testimony.